The third judgment which I want to discuss is the judgment in the case of the Internet and Mobile Association, which deals with virtual currencies. Now, that's an important judgment for various reasons. Because that deals with two or three important aspects. One is it deals with a regulatory aspect in economic affairs of a regulator like the Reserve Bank of India. It also deals with certain important principles of administrative law, like malice in law and culpable exercise. And it also deals with one aspect of Article 19(1)(g), and when there is a challenge on the ground of Article 19(1)(g) on the question of proportionality and whether a measure that is taken can be questioned or to what extent can be questioned as being disproportionate while infringing a citizen's right under Article 19(1)(g). So the first aspect in the judgment was really on the role of the Reserve Bank of India and what is its functions under Section 3 of the RBI Act. Because the issue there were circulars issued by the RBI seeking to cast some restrictions on the operation of virtual currencies. And the contention raised was that, look here, you have not banned virtual currencies. Virtual currencies are still can be used. The government has not taken a call one way or the other on it. Effectively, you have banned trading in virtual currencies or what they call virtual currency exchanges. So the first ground of challenge was that the RBI doesn't have power to regulate this because this is not currency. Since it is not legal tender, it can't be called currency, and therefore RBI has no jurisdiction to regulate this. This is rejected by the court, saying that the meaning of the word currency is not just what is recognized as currency, but what is also capable of being used as fake currency or playing the role of currency. So if something is playing the role of currency, like what virtual currency seeks to do, RBI would still have the jurisdiction, would certainly have the jurisdiction to regulate and has the power to regulate under Section 3 of the Reserve Bank of India Act. The second question that was one of the questions that was raised was, of course, of non-application of mine, but that's a decision on facts because the court found that there were various consultations and position papers and discussions in the public domain. So on facts, of course, they found that the allegation of application of mind was not made out, but that is not so important for our purpose because that was more on the factual aspects. But as far as administrative law principles are concerned, one of the challenges was on the ground that it is a malice. The exercise is a malice it suffers from malice in law and is a culpable exercise of power. Now that is rejected by the court. That is rejected by the court, saying that if someone has to succeed on the question of malice in law, you have to show bad faith. And bad faith means that the purpose is not, or the object is not to regulate the subject, but to harm those who form the target. And to succeed in showing that there is malice in law, it must be wrongful and willful without reasonable or probable cause. So that is the test that the court employed in this case as far as to test whether the action taken by the RBI suffers from malice in law. On facts, of course, the court found that there is no malice in law. It is not a culpable exercise. The additional argument that is raised in the case was that that the respondents cannot provide additional reasons in court. Now, this flows from the judgment in Mohinder Singh Gill, because Mohinder Singh Gill said that an order must speak for itself and the reasons cannot be supplemented by way of affidavits or pleadings in court. The court has then drawn or noticed that the test in Mohinder Singh Gill has in a sense been expanded or diluted in two cases subsequently. One is the Indian Railway Recruitment Board case and in 63 Moons, where the courts found that where there is an overriding or a larger public interest, then that rigor that was laid down in Mohinder Singh Gill need not be followed, in the sense that there will not be a prohibition for the respondent or for the state authorities to plead or show additional material in court, and that the strict rigor that the order must speak for itself as laid down in Mohinder Singh Gill may not apply. The last aspect touched upon in the case, and that is actually ultimately the only point on which the petitioner succeeded, because all the points that I mentioned before, the court has held against the petitioners on the question of the scope of the jurisdiction of RBI under Section 3, the question of malice in law, the Mohinder Singh Gill test. On all these three aspects, the court held against the petitioners and found that there was no merit in their argument. But on the last aspect, that is, whether the action proposed to be taken by the Reserve Bank of India was proportional, and whether it violated the right to business under Article 19(1)(g. On this point, the court has found in favor of the petitioners and said that for a couple of reasons. One is, admittedly, there was no ban on virtual currencies. And secondly, the government had not taken a stand officially whether virtual currencies were legal or not. So given these two scenarios, the court said that you have the proposed action that you have taken of banning trading is disproportionate and will violate Article 19(1)(g), because merely possessing the power, which the court has undoubtedly said that the power lies by virtue of Section 3 of the RBI Act, possessing the power or the availability of the power is one thing, but its exercise is a completely different matter. So the exercise of the power was tested, and given these facts that virtual currencies are not being banned by RBI, bilateral virtual currency trading transactions were continuing. Government was yet to take a stand officially. The court held that the RBI circular in question of 2018 was disproportionate, and on this limited ground, the court granted relief to the petitioners in this case. So these are the few cases that I thought I would discuss. As I said, a large number of the other cases, some of them Mr. Ramchandran has covered.